good morning, good afternoon, or good evening, depending on wherever you are. On behalf of Department of Law, North South University, it is my utmost pleasure and privilege to welcome you all to this webinar. Our guest today is Professor Katrin Kuhlmann, a professor at Georgetown University. Before I formally invite our esteemed speaker to deliver her talk, let me say a few words about today's topic. Those of us who study international law, we know that international law is very much state-centric. The focus of the study of international law is almost entirely on states. Although in many ways, non-state actors are having a significant impact already in international lawmaking, their impact is not studied in a systemic way. I would say this is quite unique to international law, that it is a study almost entirely focusing on its primary actors, the states. If we have a look at economics, for example, it is very much focused both on the micro and macro aspect. Our today's speaker, she has developed a very thought-provoking article, which is published in Stanford Journal of International Law. In her paper, she makes a compelling case for a relook at the way we study international law. She argues that there should not just be a macro international law, there should be a micro international law. You could argue that in a way, the approach that she takes about the study of international law is somewhat connected to some other methods like 12 or NEO. But her approach, I would argue, is quite different from those other approaches because 12 or NEO are more about movements with regard to some method of studying international law. They are movements per se, but her approach is more about a methodology of studying international law. And I would think this is not just a doctrinal approach to study international law, it also has a practical significance. In a way, what she is advocating for in her article is an approach about international law by and of the others. And in particular, I would imagine that once we take this approach, many smaller states, individuals, corporate actors who cannot have enough influence on the making of international law, maybe they would have a greater share in the making of international law. With these few words, I would now formally invite our esteemed speaker to deliver our talk. Katrin, the floor is yours.
Thank you so much. Thank you for that kind and warm introduction. Thank you for asking me to deliver this talk today, and for having me for this session, which I'm really particularly honored to do. I just presented this paper a few months ago in Sri Lanka at the Society of International Economic Law conference there. And I think that taking this idea and putting it out in different contexts in different parts of the world, I feel like is part of what this is all about. So I have a few slides that I'll use. I just want to present some aspects of the paper. I'm really looking forward to the discussion, so I hope that you all have questions that you will ask me. But I will go ahead. So this is on micro international law. This is a forthcoming paper in the Stanford Journal of International Law. And for me, this has really been work that has gone on for many, many years and has kind of come together into this approach. So let me just make sure that my slides, here we go. So why micro international law and why now? Naming this paper was really interesting. It was a big part of the process was thinking about what to call this. And I'll say a little bit more about that in a moment. But first, let me tell you why I think this research is so important and why we really need this right now. So I'm coming from the United States right now. I'm sitting in my office at Georgetown University Law Center. There's a lot happening in international law at the moment. A lot of tensions in international law, a lot of questions about the future of international law. And I think that we can safely say that international law is at some kind of a crossroads. I'll talk a little bit about where we see this in different parts of the field, but I think a lot is changing. So, our prevailing wisdom, I guess, and approach in international law for many, many years had been that our ultimate goal is to design international legal agreements and treaties at a very high level. We saw this coming out of the Second World War, the Bretton Woods institutions, this real kind of legalization, institutionalization in the international dimension. I still think that there is a tremendous value in treaty-based law, but it's being tested right now by a number of other forces: nationalism, regionalism. I'll talk a little bit today about fragmentation too, which is something that often comes up as a question as we sort of step back from this idea that there's this very completely universal notion of international law. I will say this, though. I do think that international legal norms are still incredibly important. And I think that this model for micro international law actually supports keeping universal norms in place rather than undermines that. But I do think that there's a crisis of confidence in the system at the moment. And so we still really need international rules, but we also need new approaches. We have new challenges right now, ranging from climate change to nationalism and fragmentation. So we need different ways of thinking about international law, of approaching international law. So in many areas where we have a real substantial body of international law, there are a lot of changes happening. International trade law is an area that I've worked in for many years. And when I studied international trade law, we really celebrated the fact that we had come up with this body of international rules. Again, this treaty-based body of international rules. But in the years since then, the system has shown some big cracks. The negotiating function of the WTO has not worked particularly well since the Uruguay round was concluded some years ago. The dispute settlement function is also right now frozen because the United States has not supported the appointment of new judges to the WTO appellate body. So this big change happening at the WTO. In the midst of that, too, I think there has been a push for rethinking what international trade law looks like, making it more inclusive, bringing more voices to the table. So we have both these kind of, forces to break the system down and then also forces to try to build the system up in different ways. This means, though, that we do need some new approaches, I think. In international investment law, there are big changes happening as well. We're moving away from investor state dispute settlement in many cases towards different ways of thinking about how to resolve disputes, different ways of thinking about how to ensure corporate accountability, different ways to think about the government's role in regulating the markets. In international human rights law, again, we have a vast body of international law, but we have a lot of challenges with implementation and enforcement. We see that across different aspects of international law. And then, of course, climate change and environment, where we do also have a treaty-based system. There are challenges with different countries engaging, making commitments, fulfilling those commitments. So I'd say these areas that are really well established, and this is just a sampling, this is not everything that's covered under international law, of course, but there's a lot of, we've got some things that are in flux right now. Then we have areas of international law where we don't have this multilateral system of rules. I would say right now, on thinking about how to deal with the debt crisis, we don't have comprehensive international rules. We have pieces, but we don't have a comprehensive system. Food security, which is something that I've worked on for many years, does not have a comprehensive system of international rules, although we have a patchwork of different obligations and treaties. And one thing, I finished a paper last night that I submitted on digital regulation and artificial intelligence, and looking at both how different countries are regulating in this area and then where some of the trends are in international agreements. Again, we have kind of a patchwork of things, but we don't have a full system of international law yet. We don't have a multilateral treaty. And so those areas too really make me think that we need something where we can get more into the granularity to be able to see what the future of international law would look like. Another thing that I think about and talk about and write about a lot is who's developing the rules. Are the rules all coming from Europe? Are they coming from China? Do we have the Brussels effect or the Beijing effect kind of pushing international law in one direction? Or do we really embrace pluralism and different approaches to international law? And I think that this model of micro international law is really about that. It's about the value in pluralism. I was just looking at a wonderful paper by Professor Hakimi that talks about pluralism and the power that pluralism can have to bring together different ideas, and that conflict in looking at different approaches is actually something very positive and powerful rather than something that undermines the system. I think that's very true of the micro approach too. And I think that's why it doesn't actually lead to fragmentation. It creates a system that's much more cohesive than trying to get everyone to do the same thing. So basically, complexity, which we sometimes shy away from, particularly in political rhetoric, needs to be part of the solution. As lawyers, we're actually good at complexity. It's something that we embrace, that we study. And this, I think, puts that kind of front and center. So I'm proposing that this micro approach become a subfield for all of us to think about and study as we continue to study international law as we have. It's focused on a few different things. You're absolutely right that it's focused on, so I was thinking a lot too about what are the units in this? What are the units of measurement? How are we thinking about what is micro versus macro? And part of it is the state versus all of the other stakeholders and actors who really play a role in international law. One of the things that's been very striking to me recently is thinking about the fact that each one of us is impacted by by international law. Each individual on the planet is impacted by international law. But we don't often talk of it that way. It's kind of talked about as this and viewed as this thing that's big and out there somewhere in the universe, but not something that impacts our daily lives. I think we need to change how we discuss these things. We need to change the messaging around international law and its importance at this very critical time. So I think individuals and other stakeholders, absolutely. States still play a very important role, though. And I think part of what this model is also trying to do is to push a deeper study of the role of different states in shaping international law, not just the economically powerful ones. I think another part of this is that we often, as I mentioned earlier, we think about international law in terms of these treaty instruments. So in a former life, I was an international trade negotiator many, many years ago. And one of the things that we would work towards so hard was to try to get an international agreement. Now, there's absolutely nothing wrong with that. That is as it should be. But the treaty in and of itself became kind of the milestone, getting the treaty signed, having a big ceremony around the treaty. With this model, I'm encouraging us to think not just about treaties as component parts of international law, but to think about all of the pieces that make up those treaties, all of the inputs, all of the approaches to enforcement, to implementation, to taking international law, which often is written in a way that is more general, and implementing it at the domestic level. This is something that I think that we really need to study. So I think those granular pieces are also part of this. I think it supports universal norms. I think it supports keeping a system intact. And I think it would strengthen international law to take more of a micro approach. So what exactly is it? It's a couple of things. As I think, as you said very well in your introduction, this is really about a field of study. This is a way of approaching international law as scholars, as academics, but also as practitioners. It does have a practical component. It is not just a theory. But for me, this was work that I had been doing for many years, doing, all over the world, really going out into the field, literally going out into the field, and trying to talk to as many people as I could about their experience dealing with legal systems. And I started to see all of this nuance and detail that was otherwise just not captured. So that was really what led to this approach, was a number of years of really kind of trying to test it and think about it, and then trying to see, though, how all of those experiences could be put into something that's one theory and one model. Because I often think, too, that what happens when you get this more granular information, you talk to farmers, talk to individuals, talk to small businesses, you again get a very, very rich picture of what international law looks like on the ground. But sometimes those examples are kind of dismissed. Oh, that's a nice case study, or that's a one-off, example. That's not something that shapes the entire system. But in fact, those experiences, those interactions with international law should shape the system, do shape the system, and could give more direction to where things are going. So I wanted to have some way of collecting all of that. This is intended to address gaps in scholarship. You rightly point out that there are a lot of antecedents to this. There are a lot of, it has relationship to other theories. TWAIL, for example, something that I teach in my classes and have found to be incredibly inspiring, that really calls for a rethinking of international law and a recentering around a different set of experiences and values. I think that's absolutely right. And it is a movement that I think has inspired this. Um, you also mentioned New International Economic Law Order, NEIO. That also, I think, has contributed to this, as has foreign relations law and transnational law and new legal realism. All of these have pieces of what micro international law is intending to study, but not one of these other theories has a real intense focus on the granularity, on the micro. And again, we see this in other fields. So studying that piece, studying the levels that are beneath the treaty, what goes into international law, and what really makes up international law's effectiveness in practice is something that I think needs to be studied. And there's a relationship between that granular level, that bottom up that we often talk about, and the top down, the micro and the macro. In the paper, I talk about sort of the micro kind of moving up to the macro, but they really are, it's really a circular relationship. The macro influences the micro level and then vice versa. So they kind of go together and continue to inform and inspire and shape each other over time. So it's focused on design of international law, implementation of international law, and essentially doing that through the lens of the people and the communities that international law is impacted. So we often talk about the promise of international law. International law is very aspirational, I think, too. It creates a set of rights and obligations. It creates a set of governing principles. But if we really want it to work, we need to be able to go more into those details on how that happens. Whom does it affect? How does it affect them? And what are different countries doing to be able to fulfill that promise of international law? So it's a conceptual framework, but it also has a methodology and an empirical toolkit, as I call it, that goes with it. Because I thought that a lot of other theories, too, kind of present different ways of thinking of the world. That's what a theory often does, right? But part of what I thought we needed was a way to do this, a way to actually study it, measure it over time, catalog all of that granularity, and hopefully do this worldwide. My hope is that with this paper, it will inspire a lot of other thinking and creative application. I have some ideas on where I'd like to go next with it. I'll talk about that at the end. But it's really something that I think is meant to be applied as broadly as possible so that we can continue to gather and study these pieces that make up international law at a time where it's shifting very profoundly. So the methodological part, the empirical part, I'll talk a little bit more about this as I go, and I'll actually show you part of what I mean with one of the empirical methods that I talk about in the paper. It's something called micro mapping. It's a method that I developed based on work that I was doing in Africa, but it can be applied anywhere. So this could be applied in Bangladesh, of course. It could be applied in the United States, too. In fact, I've been thinking about doing some of the micro mapping, looking at the state level in the United States. But It really is a way to look at where innovation is coming from the bottom up, where it's coming from national law and subnational law that plays a role in the broader macro international law. It identifies gaps, it identifies patterns, it provides a way of comparing things to. So comparative law, I think, is very central to this approach, but I wanted to have some focus on, again, empirical methodological approaches that could help kind of guide us forward. I also thought it would be helpful to have a bit of a roadmap, to have something that could kind of lead us to, well, what concretely can we look at? What concretely could make a difference? And so this method that I talk about in the paper of micromapping does just that. It points to where international law could be designed and applied differently, and it studies how international law is being applied right now in practice. So I'll show you a map in a second, and I think that will help kind of drive home that part of it. There's also a procedural dimension. And this part is complicated a little bit because the way that international law is often made, particularly international economic law, doesn't really integrate a lot of stakeholder engagement. There are exceptions to that. There are good models that exist. There have been attempts also at creating ways for stakeholders to participate in the process. But by and large, it's still very much done at the state level, as you very rightly pointed out in your introduction. And so there is a procedural part of this that I think needs to be studied more on how those different perspectives and needs are brought into international law, how rulemaking really could focus more on engagement of different individuals, of different stakeholders, of small companies. And it's very interdisciplinary. So when I was thinking about what to call this, as I mentioned in the beginning, the title for this was something that I spent a lot of time thinking about. And I've had a lot of different proposals since then. Maybe this should be called micro new legal realism. Maybe it should be called micro transnational law. I wanted it to be something new in a sense, even though, as I mentioned, it does build on a lot of these other theories and integrates them. So it's not meant to replace anything. It's just meant to say, this piece needs to be front and center. This micro piece needs to be something that we really study in and of itself. But when you look at other disciplines, they have a micro approach. In economics, the micro approach actually, by most accounts, predates macroeconomics. And in just about every case, micro and macro go together. So you don't think about larger scale interventions without actually also thinking about smaller scale inputs. And this is something that I think that we need to do in international law as well. International relations and political science are now bringing in a micro dimension, really studying those micro level interventions. And what do they say about the larger systems? So this is completely underrepresented in international law. And that was really the kind of impetus behind this paper. It was both to kind of bring together a lot of field work and experiences, but it was also to try to put international law on the map with these other disciplines that recognize a micro dimension. And in doing so, the macro and the micro, I think, have to be combined. So I'll talk a little bit more about how to do that in just a moment. But let me talk a little bit about the empirical approach. I'll go to the map in just a second. So the empirical aspect of this, I think, is really important. There is a trend right now in international legal scholarship and legal scholarship more generally to build in more empirical models, to do empirical study, as other fields do. This is still somewhat nascent. It's not the norm, so it's not often the way that we do things, but it is on the rise. Much of the scholarship in international law still tends to focus on what I would call the macro level, treaty formation, treaty compliance, without looking at all of the pieces below. But there are some exceptions to that. This micro dimension is beginning to emerge. A lot of my work has focused on it over the years. I think some of the new legal realism scholarship focuses on a micro dimension. My colleague Greg Schaefer at Georgetown is somebody who has worked on this. There are other scholars within the new legal realism dimension who have done this too. And so there are different ways. Of course, the empirical models that we can use are fairly consistent, I think, across some of the approaches, although the micro mapping that I'm going to present is, I think, a little bit novel. And again, hopefully will be something that we use more and more. We do mapping in other areas too. So it's not as though mapping in and of itself is completely new, but just applying it in the way that I'll talk about is something that I hope can get more traction. So some of the methods that we would use are doing qualitative research, talking to people, doing surveys, doing questionnaires, doing consultations, getting out into the field, as I mentioned, and really trying to understand what the relationship is between day to day. What do people experience? What do they need? What do they understand of the system? And that higher level system itself. That I think is really central to this. There's also the possibility, I think, for doing more quantitative work. I think legal empirical work tends to be more qualitative just in nature, but there are ways that we could bring in a quantitative dimension to this, depending on how big some of the studies are. And I also have this idea, which I have not fully developed yet, but I kind of mentioned in the paper as another thing to think about, which is that perhaps one of the models that we see in economics of randomized control trials, one of the methods from economics, maybe that could be modified more for a legal context, to try to really study what the effect is of doing certain things. So that's something that I'd like to develop a little bit more in the future. But let me show you what the mapping looks like. Now, every time I show this slide, I have the same disclaimer, and I'm going to tell you what it is right now. Don't read the map. If you read the map, you will get lost in all of the detail. The map is there, though, to show you what I mean by granularity. This is granularity. And this map is actually, it's illustrative. So this is a map of a quality control process in Ethiopia for agricultural inputs for seed that gets planted in the ground. But the reason that I show this is, first of all, this is central to international trade law. This is part of sanitary and phytosanitary measures. This is a component that a country would develop in order to implement the requirements of the WTO agreement on sanitary and phytosanitary measures. This is also central to food security. So it is something that is completely part of thinking about these other areas of international law, but we don't often go into these details. So this is a mixed method tool. It's a textual analysis, and it's also a qualitative analysis. It is based on consultations. It's based on getting out and doing those interviews and talking to people, as I mentioned before. It is also a comparative model. So what does it show? It shows granularity in legal systems. It shows good practices. So these shaded boxes are actually good practices in Ethiopia's system that might not exist in every other system. International law doesn't say that Ethiopia cannot do those things. It's just that Ethiopia has decided to do particular things, in part because of this large number of small farmers in Ethiopia. So this is related to a particular context in Ethiopia and shows some of the things that are really innovative in Ethiopia's system. It also shows implementation gaps, where the law on paper is different than the law in practice. It shows where stakeholders, where people who are using the system experience something that is different from what the law says. And I think this is really, really important to study as well. And it has a procedural dimension. It brings in that, where can you interact with the system? Where can you provide input in the system? How do individuals and small companies and large companies too, how do they interact with law? And then some of the arrows here that you can see are looking at the alignment between domestic law and international law, studying how domestic law is actually implementing international law at a much more specific level than the higher level international law would be written. And really importantly, too, I think it shows where there's innovation, where law brings in economic and social dimensions, where it enhances transparency, where it can enhance sustainability. So I think that this model really lends itself well to the micro approach because it gets into so much detail that we don't otherwise study. So how could we combine these? I'm almost finished. I have 2 more slides, which I hope are helpful a little bit to kind of center the discussion. But so one thing is I think we need to combine micro approaches and macro approaches. As I said, this is what other disciplines do. This is really something that we should be doing in international law as well. And it would lead us to different ways of thinking about the design and implementation of international law and really integrate that community level, that local level that is missing. So in international trade law, there are a lot of examples for this. One thing that I'll mention is a study that I did on Kenya and South Africa. Was looking at a possible change in rules at the WTO level if something called the moratorium on customs duties on electronic transmissions were to be lifted. And this particular study interviewed around 450 small businesses to find out what their views were on this particular measure. Most of them had not heard of it. Most of them had not been consulted by their governments, and most of them were concerned that there could potentially be a change in international law that would impact them very directly through increased costs, which, as most of them said, they would pass along to their consumers. So this, I think, is particularly important, again, considering some of the discussions that are happening right now in international trade law about changing tariffs and taxes and costs at the border. This kind of study, I think, makes a big difference. How is it really going to have an impact in practice? In international financial law, there has been a lot of discussion about all of these institutions that were created in the wake of the financial crisis. Basel Committee standards, for example. But yet we don't often talk about how they relate to what the countries are doing to actually implement these standards, nor do we often talk about who is at the table in designing these standards. So there's a study referenced in the paper that looks at this aspect, that looks at domestic regulatory innovation and how that interacts with Basel Committee standards. This is the kind of study that I think we need to be doing more and more often. In international environmental law, there are a lot of examples. I think environmental law kind of really lends itself to a local approach. And one thing that I referenced in the paper that was in another work by James Gothy, who's of course one of the renowned TWAIL scholars, is looking at Indigenous practices and where Indigenous practices can be an input into how we think about international law from the beginning, not at the last stage, not when everything is already signed and sealed, but from the outset. So this is another example of how the micro could come into the macro and how they could mutually enforce each other. And then in food security, I think there are a lot of examples. I just showed you a map that relates to food security. And as I said, this is also part of the WTO agreement on the application of sanitary and phytosanitary measures. Here, what I've seen is how domestic law really leads to the implementation of international agreements. Often these international agreements will have broader standards that require a lot more work at the domestic level and actually encourage, I think, some degree of pluralism and different approaches among countries rather than just always pushing towards one way of doing things. I really do want to reinforce that. I think that there's a lot of room for countries to come up with approaches that are tailored to them and to their stakeholders within this model, rather than just saying, you know, universal international law means that everybody does everything exactly the same. It means adherence to universal norms, but it does not mean that every process and procedure and legal system looks exactly the same, nor should they, in order for us, again, to be able to keep a system of international law that everybody is supportive of and buys into it. And then this sense of accountability and process and implementation, that dimension of this, I think, is really important. I think micro international law, micro interventions can increase engagement in international law. They provide a way for individuals to be part of the process, for stakeholders and networks to provide input into international law, and also a way to redistribute power and to build trust again in international law at a time when that trust is failing. So there's been a lot of scholarship, for example, about how to redistribute power at the institutional and international legal level. We talked about NEIO a little bit ago. There have been a lot of proposals on reforming the IMF and the WTO at an institutional level. I would say that micro approaches could really help think through what that could and should look like in a more concrete way. Regional models, I think, are really important to this too. I sometimes think about that they're like a meso level between the macro, the multilateral, and the micro, or the really granular. And I think that they can also be important. First of all, I think the domestic level really relates to the regional level. And regional models, as I've seen, I studied a lot of regional trade agreements, for example, they do incorporate a lot of innovation that we don't see at the multilateral level of international law. And they often incorporate consultation and cooperation and a way to be more engaged in the process that I think says a lot about how to think through these different areas of law, whether it's sustainability and environmental law, whether it's labor and human rights. There are a lot of models that are out there that I think could be more precisely studied. And then national models for doing this too. New Zealand has a really good example of having a system in place for incorporating Indigenous communities' needs, the Maori community, and how does that reflect in trade agreements and other international law. These, I think, are things that we could expand upon much more widely through this model. So then that leads me to the end a little bit. Oops, not that much to the end, this part of the end. Where does this go next? So this is something that I've really been thinking about very deeply. I hope that you have some ideas and some questions on this too. I do think that it would be interesting to study where micro approaches support international and universal norms rather than undermine them. What does this mean about fragmentation that we often talk about? Is this really fragmentation, having different countries taking different approaches, or is it part of what keeps the system together? I think it is the latter, but I think that that is something that could be studied at a deeper level. I also think that the implementation and accountability and engagement dimensions of this really need deeper study. What is the impact of doing certain things versus others in terms of international law? How do we know whether international law is having an impact as it aspires to do on individuals and communities and stakeholders? Are we sure that we're delivering on that? Or are we assuming that there's an impact because of how it's designed? I think that these models and mechanisms, as I was saying before, for how to integrate input and different voices into the process are something that really should be looked at more closely. And again, I do kind of go back to climate change repeatedly, just because I think there is a local dimension there that's really important. So a colleague of mine, Professor Dan Esty, writes about climate change localism and ways to bring in non-state actors into implementation of the Paris Agreement, for example. I think that could provide a lot of insight into how we think about other areas of international law. And then I think it would be really beneficial to have a deeper comparative study of all of this. I look in the paper at some examples. I did draw from experience that I've had working in Africa, but I've also done work in Asia. Not in every country, though. I'd love to do more of this mapping across the board. I'd love to collaborate with other universities and partners to do this kind of mapping, to study Bangladesh's legal system, for example, and see where the innovations are there. I mentioned at the end of the paper, why instead of just talking about the Brussels effect, why are we not talking about the Bangladesh effect? Why are we not looking at how other countries really impact the system? And being in the United States, with all that's going on here, I think it would be beneficial also to do some of the study at the subnational level. And then finally, as I mentioned before, maybe we could learn from other disciplines in terms of what this empirical toolkit looks like. Are there other methods that we should be using in law? Are there ways that we could adapt approaches that are used in other disciplines and apply them in law? So these are some of the things that I am thinking about as we go forward. But I hope that this is at least interesting food for thought. I hope the slides were helpful. I'm going to end the slides so that we can have a discussion now. And again, thank you for having me. I really, really appreciate the chance to be here.
Thank you so much, Katrin. We have quite a few questions already. The first question that I would like to put to you is from one of our esteemed colleagues, Professor Farooq Sheikh. He has actually asked several questions, so if I may put them to you. He asks, micro international law seems good on paper as addressing the micro details of all actors, but its implementation would be most onerous, wouldn't it? So that's the first question. Then he asks, is it practicable, the idea of eroding the tradition of interpretation latitude given to judges? So maybe you could address these two first, and then I would put rest of his questions to you. Thank you.
Okay, thank you. And thank you, Professor Sheikh, for those questions. The implementation of this is onerous in a sense, just that I guess in the sense that we don't have all of the information that we would need to make this work day to day. It's not onerous in the sense that we really need to be doing this anyway and are doing it in bits and pieces. Part of why I wanted to write this paper and put this model out there is that I think that some of this exists already. It just doesn't have a name. It doesn't have a structure. It doesn't have a way of us exchanging and studying and comparing these intervention points. And so I think that some of this is already happening. Implementation of international law has to go through a more micro level. It has to. International law through treaties then gets implemented and adapted by states. And that is already happening. It's just that we need to understand better how it's happening to be able to provide some of that input into the international legal process, I think, itself. Now, your question about judges' interpretation is really important, and it's something that I've been thinking about. I don't think that this is saying that interpretation is going to go now to the field and come out of the courtroom. That is not what I'm advocating for. I still think that judges, tribunals, I think that there is a tremendous role for that interpretation. But again, I feel like we're missing some of the information that we need. We're missing more detailed study of what is happening at the country level. This would help, I think, to reinforce the system of interpretation that we already have. I also think that judges are interpreting different aspects of the system than this purports to do. So they're interpreting language, they're interpreting application of a treaty, they're, interpreting kind of, again, that more macro level, higher level international law. This is really looking more at all of the pieces that inform that. So it's not trying to take away the interpretation that exists through international tribunals. It's just meant to study the factors that contribute to international law and that do play a role in its implementation. I often find that when we talk about implementation, we talk about, at least here in the US, we talk about implementing regulations. That's not what I'm looking at here with implementation. Here, what I'm trying to get at is how international law is being interpreted through different national systems. And, a court might decide whether those national systems are in compliance with international law, right? Are they interpreting in a way that is consistent with international law? This is meant to look at the different pieces, hopefully, that contribute to a system that is in compliance, but might be a little bit different from state to state. Does that make sense? Did I answer your question adequately? I'm happy to engage more, though. I think those are both great questions.
Thank you. So Professor Sheikh's next questions are, as I listen to your talk, it seems that micro-international law is quite like localized, user-friendly implementation of the macro. Would this be right? So we are not really giving up treaty-based laws, but are proposing to lend the treaty-based law a finer and detailed plumbing, like the human capillary network in our vascular system, to address and oxygenate all microactors. Would this be right? Your take on that, Katrin. Thank you.
Excellent. I love how you framed that question. I was talking to somebody about this last week. I gave a talk on this last week at University of Georgia. And I was saying, I think international law is like the tree, right? It's this big, strong structure, the treaty-based system that you can see. This is like the roots. This is everything that's underneath. I like your analogy to the capillary network. It's all of the little pieces that strengthen and support that larger system. So it's not meant to undermine international treaty-based law. We still need international treaty-based law. But I think that we also have to be, we have to recognize the fact that right now, the system is moving in a lot of different directions. And so we have to study that system that goes behind it. I think you're right, though. I think this is about localized approaches. I think it's about making it more user-friendly. I think it's about making it accessible. When I started the conversation, I said that one of the things that really strikes me right now is that there's so much discussion, at least kind of, in international news networks, about whether international law will even continue. What does it mean? Does it still continue to apply? Does it continue to hold? And I think it does, but I think that we are going to have to do more work to make everyone see how it applies to them, to keep the system in place, and to be able to maintain aspects of the system that I think right now are in question. So I do think that you're right. I think it is partly about localized and user-friendly approaches. I think, to me, also part of it is about really studying those granular interventions that make up international law. And I think that's part of your question before about, is this onerous? I think that's a lot of data that we need to collect, right? That's a lot of study that we need to do. But I'm confident that we can do it. I have done this now for long enough that I can see that it is very possible to do this kind of research. And I've been able to see also the value in doing that research. So I probably should have told a little story too about that mapping example that I had, which is that I've done this now in a number of different countries. And that micro mapping has led governments to look at their system a little bit differently. So instead of trying to respond to challenges, well, the system is just not working or the system is perfect. And it's usually neither one of those, right? It's usually somewhere in between. That micro mapping, that very granular level mapping, enables governments to say, okay, small businesses, NGOs, individual farmers feel like you're not part of the system. Here's a place where we could make you more part of the system. Here's where it could be made to work better for you, so that this is not just law that we have on paper, that this is actually something that works in practice. And I have seen this now over and over, that it leads to very different results than the way that we typically talk about some of these systems. So I think there's a tremendous value in it. I've also seen that these micro level interventions have led to legal change at a regional or international level. So they have been able to move from the bottom up to make change at the top level. And I really do find that it's kind of this circular system. I think that your reference to the capillaries is really important, because you need every part of the system working together, right? And so this is just saying, let's look at that smaller scale part, so that we can understand it, so that the whole system as a whole can be healthier. These are
Thank
great
you.
questions. Thank you so much.
Thank you for the question, and thank you for your great answers, Katrina. The next question that I would like to place to you is from one of our undergraduate students, Ahmed Musa. So he asks, if micro international law were to be widely adopted, how do you
Mhm.
think it change the way international treaties are negotiated and implemented? Could it lead to more localized context, context-specific treaties, or would it still aim for universal norms like we see today? Thank you.
I think that's a fantastic question. Thank you for that. I think that this could change how we negotiate treaties. Again, part of my background comes from doing that, and from seeing what goes into the process of negotiating treaties. And I remember thinking very clearly, I wish I had more information. I wish I knew more about how the words that we're putting into this treaty could really have an effect on people. This is designed to do that. So my hope is that if this, does gain traction, which I hope it will, I hope that you will all take a piece of this away with you today and do something with it, and, reference the paper, but build on the paper. I mean, I would love to see that happen. And my hope is that if it were widely adopted, that it would change how international law is created, that it would provide these other pieces that often kind of get pushed to the side. Again, institutionalize and give credibility to these smaller pieces, these more local interventions, so that we have to think about them as we're thinking about how to shape international law. We cannot ignore them. We cannot dismiss them. Um, Now, is it going to still lead to universal norms? So again, I think we still need universal norms. We need to agree as a global community on international human rights norms, for example. We need to agree on the norms that underpin a lot of international law. Without that, I think the system doesn't work. But universal norms are very, very high level, right? There is so much in between a universal norm and a system in practice that delivers in a number of ways. My example of Ethiopia, again, is very, very granular. It's about food security. It's about sanitary and phytosanitary measures. It's about these really specific things that come from international treaties, but then have to get adopted and adapted and implemented at the national level. That doesn't mean that we don't still have international norms. So in that particular area, then we would still have a recognition that these systems should be based on science, that they should be done with a risk assessment, that they, should fulfill certain, they should be done, in the name of, human health and safety, right? There are aspects that will still underpin a system like that. But here we're studying more what that looks like in practice and what those pieces are. And my hope is that by being able to identify, study, isolate those pieces, that we can bring some of them in as other systems are developed. So Ethiopia's more farmer-focused model is something that maybe then other countries could consider as their developing systems. If there were to be additional international treaty work in this area, which I think there will be, on biodiversity, on food safety, on sustainability, I mean, these are fields that continue to evolve. Some pieces of Ethiopia's model may be considered then as new international treaties are developed. And again, I hope that we would have input from a range of countries so that that could all kind of filter up to the top. I hope that answers your question. But that is indeed my, that is my hope with this, that it could change how we approach international law, but that it would not undermine universal norms. It would just strengthen them.
Thank you, Katrin. The next question is from one of my colleagues, Muhammad Lukman Hussain. So he is asking, what are the risks of this categorization of micro international law? And if I may add to his question,
Yeah.
could critics then say that this micro international law is not really international law? Because most of us in international law academy, we still tend to think about international law based on the Westphalian model. So your thoughts on that, Catherine? Thank you.
Such good questions. What are the risks? Well, I mean, I think one of the risks is what Professor Sheikh also pointed out, right? That it's a model that takes a lot of effort to advance. To do all of this is going to require more study, more resources, more attention from parts of us. Again, though, I would maintain that a lot of this is happening in pieces and is not being pulled together. And so I think that that risk of kind of diverting resources into something is not necessarily as big a risk as we would maybe think. But I suppose that there is always a risk, right, in proposing a different way of thinking about things or a different set of inputs. I feel like, though, the risk of not doing this is much greater than the risk of doing it. The risk of not doing it, I think, is that we have an international legal system that really does start to disintegrate. And I don't want to see that happen. So this, for me, is also a way of trying to find some hope in the system and trying to provide a much broader role for a lot more people and keeping the system going. So I think that there are always risks, right? There are always risks with trying to do too many things at once. But hopefully, again, the cost of doing this is outweighed by the benefits of doing it. So I think on your other point about, does this undermine the way that the Westphalian model and the way that we have approached international law, and how do we reconcile that? Um, Again, I think that we do not move away from the way that we have approached international law in the past. The reason that I said that this is very interdisciplinary and draws from other fields is that I think that other fields are recognizing that you can really study the macro better if you also understand the micro. That's what this is meant to do. It's not meant to do away with the macro. It's not meant to undermine that. It's not meant to undermine that international treaty level. Um, I think that there probably are aspects of international law that we could reconsider, though. And I think that some of these other models that you talked about, that we talked about TWAIL, for example, with so many amazing people writing in this area saying we need to really fundamentally rethink international law. I think that that is something that's already being discussed. And I do think we are going to have to rethink international law, because I think that the world is changing in a way that is going to push us towards different, a slightly different way of framing things. I don't think that it means that we do away with everything that we have historically studied. I think it just means that we need some different inputs. We need some different approaches. We need more tools in our toolkit. The issues are becoming more and more complex, and they're becoming more and more integrated. And I think international law is becoming more and more interdisciplinary. So why not borrow a model from other fields and adapt it to international law? You'll notice if you studied economics, this is very different than microeconomics. It's not saying that we study the firm level. It's saying that we study smaller pieces. And in international law, those smaller pieces look different than they do in other disciplines. But I'm just absolutely convinced that we have to do it. I have seen time and time and time again that when we stay at too high a level, we are not able to really engage in a meaningful way. And it's something that I think a lot of countries have a hard time buying into. Again, I think it's, something as lawyers that we do also. If you think about, this question came up earlier about where do judges and courts come up? Judges and courts are really thinking about things at a more micro level. They're picking things apart. They're picking apart language. They're picking apart a treaty. They're not necessarily even always offering it an opinion on everything. They're looking at a particular detail and really going into that to be able to interpret particular language or how something should be applied. Why, again, are we not doing that with the design of international law? And why are we leaving everything for interpretation in the courts, too? I would say that a lot of this doesn't ever go to a court. A lot of this is just international law functioning day to day. So I think that we need to have that more granular dimension for the day-to-day study of international law to make the system really work better in practice. We don't want everything to go to a dispute or to go to court, right? That's going to be a last resort. And in many cases, it's not going to think through all of the questions that I think that this model could help us think through over time. So I hope I'm answering everything sufficiently. Please tell me if there's something that you want me to go back to or elaborate on more.
No, thank you. I think that's a great answer. And a related question, if I may ask, as you have rightly pointed out, the Brussels effect, that seminal work by Anu Bradford. So, if we emphasize this micro international law approach, is there a real danger that we would have a Google effect or Microsoft effect in international law? Can you see that?
So one of the things that the paper tries to do, and I thought very hard about this, was not just say this has to be, every not every kind of micro level input is the same in a way. It gives a little bit of a normative framing to this too. So it pushes us to think about the pieces, but it also pushes us to think about the pieces normatively. So if we do that, I mean, you could even say that the Brussels effect is kind of a micro in a way, right? It's, the EU pushing law in every other case. But it's the EU doing that from a position of power. And I think that part of what this model is designed to do is to challenge some of those power structures with the details. Again, as lawyers, if we're armed with the details, we are able to do so much more than we are able to if we don't have all of the details. That has been a lesson that I have learned over and over and over in my career. You have to do your homework. You have to do it, 10 times more if you really want to change anything. And you always have to know the details. And so I think that with this model, again, this is not about taking the most powerful approach and getting everybody else to adhere to it. I think Professor Bradford's work is amazing, and I think it's a brilliant way of really thinking about that phenomenon that we see in international law. All the more reason I think that we need something like this, though. We need some way of saying not every country should be following the EU model. Not every country should be adopting the GDPR. Not every country is going to be adopting EU law. In some cases, this example that I gave of food security and trade is because there have been these very detailed regulatory models that have been, imported from other countries, imported from Europe often, that don't really work in a particular local setting. They're too complicated and they don't think about local considerations. And so this is meant to be a little bit of an alternative way of kind of ordering the world, knowing that the Brussels effect is already happening. But this is not meant to say, let's just put power in Google's hands. So we don't go from the state to Google. We go from, Europe to the rest of the world. We go from Google to small businesses. So I think it depends also on what the kind of unit of comparison is. But to me, Google, not to, we're not picking on a particular company, but I mean, it's just saying Google has a lot of economic power. And so having concentrated economic power is part of the reason to have a model like this, so that there's another way that we can kind of think about what influences international law rather than just that concentrated economic power. Does that make sense?
Thank you. Thank you, Katrin. We are almost out of time, so this would be our last question. This question is from another colleague, Mr. Nafiz Ahmed. His question is, if this method is accepted widely, how would it affect the current international law framework? To be more specific, how may it interact with Article 31 of the Vienna Convention on Law of Treaties?
So again, I don't see this as being inconsistent with Article 31 of the Vienna Convention. What I would see changing in international law is something different. I would see perhaps more of a movement to have local approaches become adopted at an international level. I think about something like traditional knowledge. I think about local approaches in sustainability and climate change. I think about more, local models on markets and trade and having those filter up to the system. I think about giving weight to treaties that sometimes are more abstract and general in the way that they're constructed. Treaties on biodiversity, for example, on access and benefit sharing. I think about some of those things getting more traction because of a model like this. I don't see it as interfering with the Vienna Convention and with international treaty interpretation. That is just, I guess, my take on it. I think it'd be interesting to think about whether there are examples of where this could conflict, but I don't see that as being the risk to this. I see the ultimate risk just being that this is information that is scattered throughout the world and perhaps hasn't really been collected in the way that I would like to hope that it could be. And the risk is, can we do this fast enough and deeply enough that it's going to really provide more input into international law as these new things evolve. I guess one thing that I'll end with is, again, a paper that I have just finished in draft and submitted, which is on digital and AI. So I look at an area like digital and AI, and I see tremendous potential for good. I also see tremendous potential for something that is going to lock a lot of people out of the system. And in something like that, I think that we really need to think carefully about, how are these systems designed? Whom are they designed for? Are they being constructed in a way that's going to help every individual assert rights? Or are they being designed in a way that's really going to give power to the large companies? This is something that I do worry about. And I think that this model is particularly applicable in a case like that. As I mentioned, a place where we don't have multilateral international law, we don't have a set of international standards. We have kind of Europe's model that's being pushed out, but I think even Europe's model, needs some refinement and maybe doesn't apply in every case. So here I would love to see where there's more creativity that's happening from different places, and also where there are particular needs and concerns that are coming from developing economies, that are coming from smaller stakeholders. I think that should inform where we go with international law in that particular area. So that's an example of where I see this kind of model really being useful. I do still think that we are going to have international treaties as we have known them. I don't think that it's a departure from that. But hopefully it gives us a different way of thinking about what international law could and should look like, so that we wind up with a system that is really beneficial to as many people as possible.
Thank you, Katrin, for that excellent answer, and for once again for your excellent talk. Dare I say that I see your article as a paradigm shifting article. So I don't think we can do justice to your work in just 1 hour. I'm reasonably sure that this dialogue would go on for quite some time, and maybe we would see some radical shift in years to come. So thank you once again for your time. Thank you all for your time and questions. We look forward to having you among us in our next session. Have a good day.
Thank you. You too. Thank you so much.
Thank you.